your levity right now. So thank you.
Thank you, ma'am. You too.
Bye-bye.
Bye-bye.
All right. State of Michigan versus Melissa Floyd, case number 22 FB 1106.
Rachel Duffy for the people.
Assistant Public Defender, Child Security Act, really on behalf of Ms. Melissa Floyd. Ms. Floyd, can you state your name for the record, please?
Melissa Floyd.
All right, Ms. Floyd, you're here for a review today.
Miss Washington, we meet again.
Apparently a lot, Ms. Floyd.
And it ain't just for me, though, either. It ain't just for me.
Are you okay today?
I'm great. I'm great.
First of all, you've been typing some information into the chat.
Because somebody is messaging me that I wish not to message me, and I said what I said.
You understand that that can be seen by everybody, correct?
Yeah.
Ms. Floyd?
I saw that. Yeah, I wanted this person to just stop.
So, Ms. Floyd, you're here for a review today. Why do you keep testing positive for THC, Ms. Floyd?
I thought that was okay. Like in the beginning, me and my probation officer discussed that. And I told him that I have mental illness in which I do not enjoy taking psychotropic medications for depression and anxiety and PTSD. So I choose to smoke marijuana. And I told him that. When I initially filled out my PSI pre-sentence report, I put all that on there.
You have to get permission from me to be able to use marijuana, ma'am. You need a letter from your doctor. Is this medicinal?
No, but I thought that was okay. Like they haven't, I mean, nobody's told me that they had a problem with it until you're just saying something now. And I know you've been seeing every time I drop.
I actually don't see every time you drop now.
Oh. Now I can't see anything. I don't like taking psychotropic medications because it screws with other things. It might make you feel...
I heard you say that. Why don't you go to the doctor and get a prescription?
Prescription for what?
For the medicinal marijuana, ma'am.
I had to get my, I have to get my medical card reinstated. I let it go expired because it's become recreational. So, but
well, you're on probation, so you can't just do recreational marijuana. You have to have a card, ma'am.
Judge, I'm
confused because they knew all that. I've been upfront and honest with probation this whole time.
Judge, Ms. Floyd is working with our social work department, so I can definitely let them know that that's something that she'll need assistance with, getting the information so we can request approval from the court.
And if we can, if the court finds it appropriate, could we just have Ms. Floyd do an ETG and SIM panel within the next 24 or 48 hours, please?
Thank you.
A what?
An ETG test and a 10-panel test to make sure you're not using any additional substances at this time.
All right. All right. Tell me where to go.
All right. To community corrections, I believe you're testing over there already.
Yes.
So I know that you're already testing. So the 10-panel they'll already have. The ETG will be the additional thing that you're testing for.
What is ETG?
It tests for alcohol, Ms. Floyd.
No problem there.
I'm sorry?
I said there's no problem there.
Oh, okay. All right. Defendant is continued on probation. ETG and drug test within 24 hours.
Before the end of today or like early tomorrow morning or?
Tomorrow morning before like 11 o'clock tomorrow, ma'am.
Okay. And in which case would I pay the $12 or no?
I think it's more with the ETG test. There's an additional fee for the ETG test. You have to talk to community corrections about that.
Okay.
1 second. Can you still see me?
Mm-hmm. We see you, Judge.
Yeah, I see you.
Okay. My computer is acting up. You're all set, ma'am. I'll see you back in 45 days. I think that puts us on August the 15th at 10 a.m.
Okay. Thank you, Your Honor.
Thank you.
In your name, so we stand now in the gap. Lord, believe that you will continue, Lord, to look upon Ukraine. Father, look upon Africa. Lord, those places that are in war-stricken areas, Lord, look upon your people. Father, we're asking that you look upon your people, that you would deliver them from the hand of the enemy. In the name of Jesus, we know that the battle is not ours, it belongs to you, but we are victorious in your name. Father, we are victorious in your name, so we stand now in the gap. Lord, believe that you will continue, Lord, to look upon Ukraine.
What's up, people? Little midday live for you, coming at ya. What's up, everybody? Oh, God. If I could start every live with Judge Bryant praying, I'd do it. I'm going to reach out. Judge Bryant, lead us in prayer. Should be like our team priest that they have for the Giants and the Jets. We'll have Judge Bryant. That was awesome. I don't know where I found that. It popped out of nowhere. That was awesome. And how about Washington? Oh my God. What did she do to deserve this torture the last couple days? Oh, this poor woman. What's up? How we doing? I saw somebody, Amazon girl, thank you very much. Member for 2 months. She said it seemed longer. I think it felt longer too. Well, you're a nerd. Always will be a nerd. I have so many clips from today. I had to release them. South City Part 3. He's in his van. I have a guy who rolled down a river naked. I wish we had video. Oh my God. But how about let's start our day off at the dentist. Judge Thomas had some guy just screw it. I'm getting my teeth cleaned, whether I have Zoom court or not.
Madam Clerk, whenever you're ready on the next case.
I'm here, Ray.
Okay, thank you. I see you.
Here, okay. Put some water there.
Okay. Excuse me, Your Honor.
Yeah.
This is Dante Coates. I'm on Zoom at the dentist office.
Hold on, guys. I gotta show you. I gotta blow it up right here. Ready? Laura! Here we go. Ready? Okay, so I'll bring it back because I forgot where it was. So we're looking at our man, Mr. Coates, right here. All right, hold on. So, Mr. Coates, I'll bring it back for you. Sorry about that. Here we go.
Madam Clerk, whenever you're ready on the next case.
I'm here, man.
Okay,
Dentist.
thank you. I see you.
Here, okay, put some water there.
Okay. Excuse me, Your Honor.
Yeah.
This is Dante Coach. I'm on Zoom at the dentist's office. My phone is on 9%. About to die.
You didn't take a charger with you?
No, ma'am, I didn't. I'm sorry. My house is right here. I should be here, maybe 30 minutes?
Well, I suggest you go home and plug in your phone. Your attorney hasn't signed in yet. Lucky you. But you better come back.
I'm coming back. I just don't want to be in trouble, Your Honor.
All right.
All right, thank you so much.
Now we have seen it all. We have absolutely seen it all. Laura, thank you for your membership. OG Mod, the modest with the mostest. She loves when I call her that. Thank you for being you, Laura. You are a super fan, OG. All right, here we go. Now we're going. Now, Judge Bronlick, if you hear what this guy's addicted to, we may have to bleep it out. We are a very wholesome show here. So, he's a little dirty boy. And it's sick what he does, too. Here we go.
Reaction, but the parties need to get medical diagnosis of that. So it seems like there's conjecture on everyone's part right now, whether it's heat rash or whether there's actually a reaction to the donut that this child allegedly consumed. In any event, the parties have met with Mr. Pratt this morning. Mr. Pratt has provided the court a fine recommendation. Parenting time shall continue per the prior court order, which is the dad having, as I recall, Tuesdays to Thursdays, 10 to 12:30, Sundays 10 to 6, supervised by paternal grandparents. Their father shall not have his phone on during his visits unless there's an emergency. It doesn't need to be checking his Facebook and Twitter accounts. Further, the party shall communicate via app close regarding the child only. It's further recommended that the father, Mr. Neva, shall enroll and complete a parenting class as well as undergoing.
Thank you, Amazon Girl. Grab your memberships. Thank you, Amazon Girl. Loyal. Awesome. What a community. Thank you, Amazon Girl.
Assessment for sex addiction.
Oh, there it is.
Mother shall provide all medical.
Here we go.
Further recommend that the father, Mr. Neva, shall enroll and complete a parenting class as well as undergo an assessment for sex addiction. Mother shall provide all medical information regarding Sophia to father. And the party shall seek explore the opportunity to attend co-parent counseling. That's the recommendation. The court does note there's a review set for August 22nd at 10:30. That's for our docket. I don't know what the parties want to do about that. Perhaps we should keep that in our docket to review.
Your Honor, I think we should move it out further because the thing is that mediation in this case is set for September 11th. It was originally supposed to be set for August 17th, but I guess for whatever reason that no confirmation ever got sent, and so I had my secretary reach out to Mr. Dayque and Mr. Godfroy's office, and then by the time that happened, as soon as they could get them in was like September. So I would suggest having the review after mediation.
Mr. Dayque, is that on your schedule, September 11th, media with Godfroy?
That's correct.
All right. So yes, we can certainly vacate the August 22nd date, and the party can simply, will someone do a stip in order, Mr. Berger, to do that the review September 11th, that shall be subsequent to the mediation with Godfroy, whatever time Godfroy is scheduled the mediation.
Okay. Yeah, that's fine. But I mean, my client does object to the recommendation in one respect.
Okay.
Specifically, she believes that parenting time should take place at her home entirely until the next hearing, Your Honor, because he's already been doing the weekday parenting time there. And up until this point, it had actually been going halfway decent. But the thing is that we don't know what's going on at his father's house. We don't. I mean, if he's watching porn over there, we're not going to know about it because there's no camera there to show whether he's using it, whether he's doing it or not. He's already done it once. And it wasn't just an accidental click either. I mean, this is clear that he's intentionally watching it with the child right next to him. I mean, I don't know if the court's seen the video or not, but it's concerning, and we believe that parenting time.
Now, that raises a big question. Is he doing that on purpose in front of the kid, or he's just so addicted that he doesn't care that the kid is there? Is he getting off on the fact that the kid is in the room? I mean, is that the concerning part? I mean, yeah, we laugh and kid, but this is scary. This guy's a creep. And I completely understand where the mother's coming from. I mean, I wouldn't even bring it even, it's just something that's just not in our realm. Well, at least I hope so in my chat room. But, oh my God, this guy.
Should be at my
Yikes.
client's house until the next hearing and until he, is assessed and if treated for, his sex or pornography addiction.
Mr. DQ.
Your Honor, the safeguards that Ms. LaPrade has suggested would take care of that. If you want to add something in there that identifies to the supervising adult third party that he's not to view things on his phone, the same type of condition on it, that would be satisfactory on our end. We can test the factual issues that have been put forward in the motion. I did review the video. I don't have an explanation for my client's lack of judgment in clicking on something on his phone. I do suggest to the court that if you view the video, the child is sleeping while that occurs. There was no risk of harm to the child, but if you want to add that extra safeguard, I think that would take care of the defendant's concern.
What video, though? If the kid's sleeping, who's taking the video? I don't get that.
But
Well,
go ahead.
This court has no jurisdiction or authority to control the activities of the grandparents, the paternal grandparents.
You don't have necessarily jurisdiction over the grandparent, but you can establish rules that the supervisor has to take into consideration.
Kitch, is that a new kind of viewing corn? He's watching Corno?
And follow with a duty to report.
But there's no way to enforce the order about reporting, though. That's the thing. Because the court can't. The court has no jurisdiction over that person. It can't force that person to report.
All right. So, what time is the mediation with Godfrey on September 11th, Mr. Berger? Is there a specific time that's been set?
Yes, it is at 9 a.m.
All right. So, who can prepare the stip and order adjourning this review from August 22nd at 10:30 to September 11th after the 9 a.m. mediation with Godfrey?
You want to take
Your Honor?
I was going to say, you want to take care of it?
Sure.
Mr. DQ, you'll do that? Okay.
Yes, sir.
All right. The court has reviewed the motions, briefs filed by both parties. And the court's suggestion, and I'm not going to order this, but the court's suggestion is that they contact or talk with a pediatrician to get a referral to a allergy doctor.
Okay.
Because obviously allergies are serious matters nowadays. And obviously the court suggests, Mr. Nemi, if there's a question of doubt, you get that child to an urgent care or the emergency room. If in fact you closely monitor a child who's having rashes and allergic reaction, make sure that child's breathing properly. But at this point in time, the court, there's not medical documentation to show this child had a medical allergic reaction. That father.
And I don't even know what's more concerning: the fact that he's watching Corno, or that he's not taking care of his kid's allergies. Are you kidding me? Anaphylactic shock? The child is dead in minutes, and this guy's not even. He's too busy watching Corno.
Should have been aware of. Could have been a heat rash. Court does not know, but anyway, the court will adopt the recommendation of Mr. Pratt for any time we shall continue as previously ordered. Mr. Nemi, you shall not use your phone during your visits. Your focus should be on your daughter. All communication should be via app close. Mr. Nemi is ordered to complete a parenting class. Perhaps the front of the court can provide recommendations as to what agency that should be, and also father's ordered to undergo an assessment for sex addiction. And the court would expect all of this to be done when we come back on September 11th. Finally, mother shall provide all medical information to father. Mr. Nemi should know the pediatrician and talk to the pediatrician about these matters. Two of you should maybe have a joint conference with the pediatrician. Finally, the parties shall seek the opportunity to attend co-parent counseling. And perhaps it might be, Mr. President, possibly you can just add a sentence, this recommendation if you're still there. good morning. Is it possible we can add just a sentence and may save everyone the time? If we can indicate that the review of August 22nd, 10:30 is vacated, and the parties shall appear to review all issues on September 11th, subsequent to the 9 a.m. mediation with Attorney Godfrey. That would eliminate the need to do a step in order, Mr. DQ, if that's agreeable.
Oh, absolutely. Thank you, Your Honor.
That's fine by me.
Thank Mr. Pratt for doing that. So we can put that right in this recommendation, which the court will adopt as an order. So again, the August 22nd, 10:30 is off our docket, and then it'll be scheduled September 11th, 2023, subsequent to the 9 a.m. mediation with Godfrey.
Your Honor, there was one other matter, and that was, and it wasn't actually addressed in the recommendation at all. I just realized this: the him showing up late or bringing the kid back early. We need to address this somehow because it's messing up my client's entire schedule. We want it so that if he's more than 15 minutes late, or if he drops the kid off early without it being arranged prior to the parenting time, that he loses the next parenting time schedule, because this has got to stop. I mean, he claims he's not doing it.
Your Honor, the problem that we have, and it's been addressed on each of the different times that we've talked about this tardiness issues, that he is reliant on his the paternal grandfather for transportation who works midnights. And so he has to have that person in the car when he transports back and forth with the child with him. That has created some logistical errors. It's not a scenario where the defendant is trying to mess with Ms. Hillman's schedule in any form or fashion. He's doing everything he can. There's a lot of driving time that goes into this as well. Then there's also the issue that the defendant continues to have him drop the child off at different places. It is not necessarily back at the child's home. And so I think we just leave it the way it is right now. And I don't, if it's because Ms. Hillman has, work or something like that, I can understand where the complaint is coming from, but I don't understand the part about the child being early and the tardy. If the child's being brought back late, I think that the app close communications that we've implemented will take care of that.
The court sees it more of an issue when the dad is when they're meeting for parenting time. I mean, Ms. Hillman should have to wait 20, 30 minutes for Mr. Neiman to show up. So is it, the problem, Mr. Berger, is it more on the pickups or drop-offs?
It's more on the pickups. There has been some on the drop-offs, but it's really been more on the pickups.
Okay.
Yeah, because if my client needs to get somewhere or has an appointment or something like that, she has to wait for him to get there, and that doesn't make it.
And what about if Ms. Hillman picks up and Mr. Neiman drops off? So Mr. Neiman's got to, if he drops off early and Ms. Hillman's not there, he's got to wait for her. So what about that? What if we flip it around? Ms. Hillman can pick up.
I don't. My client would have to say whether that's a possibility or not. Chelsea, you can't just shake your head. You got to actually unmute and tell the court what your issue with that is.
Right now, there's no way I can do that. My vehicle's down and it won't even run. I've been driving with my mom right now. I have to get a new key for my car. My car will not turn on at all.
Okay. Is Mr. Neiman transporting both ways then? He's picking up and dropping off then? Is that what's been occurring?
Right. Yes,
that's what's been going on.
Well, I'm not sure there's any solution to that issue then, Mr. Berger. If your client is on a vehicle, Mr. Neiman, just make it work. If maybe you need to find someone else. Obviously, your parenting time needs to be supervised by your grandparents. And maybe if we need to find another person to pick up and drop off, so it's timely. You got to be courteous to other people's schedules.
The problem, Your Honor, is that they've mandated and demanded that it be that individual who does the transportation.
No, it could be the step grandmother too. It's not just the grandfather. So it could be either of them.
Well, it also could be the grandmother or her husband, his stepfather.
Well, that's not. I mean, we don't think that that's appropriate because there's been issues with the paternal grandmother in this case.
No, there hasn't.
Yes, she has. She's been calling my client names. She's made horrible comments to her about my client. She made horrible comments about my client. She badmouths her all the time, and we don't want this happening in front of the kid.
It won't happen in front of the kid, and we contest what you just said. That's not factually true. And any disparaging remarks have gone both ways between your client and the grandmother. But even if she says bad things about the mom, that was not done in front of the child, and there's no risk of harm with the mom. In fact, she has medical background as a nurse.
Right, the courts believe things are the way they are, Mr. Nemi, be timely. And if in fact this continues to be just a constant problem, the court's going to address this when you come back in September.
Also,
you got to be courteous, make it work.
And Your Honor, I don't know if the court will entertain this because this is not in my motion or anything. This is just our discovery responses are well overdue. I just need a timeline on which I can expect to get this stuff back, because I don't want to have to file a motion to compel if I can avoid it. I just need to know how long it's going to be.
14 days.
Okay, 14 days. That works.
Thanks.
Okay, so all right. So with that, the court will adopt the recommendation, and Mr. Nemi and Ms. Selman try to be flexible and communicate with each other via app close. If in fact, Mr. Nemi, you're going to be late, communicate that to Ms. Selman. I mean, that's one way to address that. If you have a problem with transportation, communicate that. All right. With that, we'll see everyone back on September 11th then.
Thank you, Your Honor.
Okay. That was very interesting. Even got a little lawyer fighting. This was a good one. That is marked on the calendar. September 11th. Okay, here we go. Are you ready for this? Oh, I don't think you're ready for this. 175 in the chat. 175 of you will definitely laugh. And if you don't find this comical, there's something wrong with you. Oh, boy.
And resisting a peace officer by way of flight. You are also charged in the same case with drinking or possessing an open.
The key word here is flight. Flight.
Container of alcohol in public, and then possession of a glass container in a park. These all alleged to have occurred on June 14th of this year in the area of 1505 Idlewild Drive. Do you understand each of those charges?
Yes, Your Honor.
How do you wish to plead to the obstructing and resisting charge?
No contest.
With that plea, Judge, I'll make a motion to dismiss both counts 2 and 3.
All right, thank you, Ms. Ginoli. All right, Mr. Beeson, do you understand that by entering that no contest plea, you'll be waiving your constitutional trial rights? There will be no trial on the matter. We'll proceed directly to sentencing?
Yes, Your Honor.
All right, and the city has agreed to dismiss the open container charge as well as the unlawful possession of a glass container at a park in exchange for your plea to the obstructing and resisting charge. I will accept your plea of no contest and find you guilty of obstructing and resisting the peace officer by way of flight. Ms. Ginoli?
Your Honor, here law enforcement received a report that the defendant was at Idlewild, I believe, during Food Truck Friday and was running around naked. When law enforcement made contact with him, he rolled away from law enforcement and floated down the river, where he was thereafter caught by the Reno Fire.
He floated away. He rolled and floated away. Have you ever heard that vocabulary in the court? We have to play that back. Listen, how do they not laugh?
Of obstructing and resisting the peace officer by way of flight. Ms. Ginoli?
Your Honor, here law enforcement received a report that the defendant was at Idlewild, I believe, during Food Truck Friday and was running around naked. When law enforcement made contact with him, he rolled away from law enforcement and floated down the river, where he was thereafter caught by the Reno Fire Department. It appears that he's also being held or will be seen shortly, Judge, on a failure to register case out of the RJC. So he's probably got other things to be dealing with. I do not have his criminal history, Judge. His risk is a 7. I'm going to defer to you as to an appropriate sentence here.
All right, thank you.
He was at Food Truck Friday in Reno. Can you imagine the cop? We got a floater. What? He's rolling. His wee-wee is floating down the river. I can't.
Mr. Conway.
Your Honor, I just asked the court to consider a credit time served. It does sound like he has other things. This is a case where, he kind of actually, it's the flight was by river, which you don't see very often, but that's what he did. He kind of jumped in the river and took off. That way floated down the river until someone was able to pluck him out of the water. So I'd ask for credit time served.
Thank you, Mr. Conway. Mr. Beeson, anything you would like to say before I sentence you, sir? You're not required to say anything, but you are welcome to.
Yes, Your Honor. I had just gotten a job at the Mavericks gas station 3 days prior to this. Was having some family issues and
the icing on the cake, he just started a job.
had a drink at the park and was swimming when I was approached and swam down the river and then was arrested down the river a mile down. So I would hope that I can get some community service or something to show that I'm trying to be a citizen again and get back into the society and get back to my job.
All right. Did you have more than one drink, perhaps?
It was a couple drinks, Your Honor.
I'm just curious because people don't usually find themselves naked around Food Truck Friday swimming down the river in 50-degree water. So I got to chalk it up to something. It's either too much to drink.
I
or
wasn't
something else is
naked,
going on.
Your Honor. I was not naked.
Well, that's what it describes here. The person was completely naked.
I was in my jeans when they arrested me.
All right. Look, 7 days in jail is what you've already spent on this case. It'll be credit for time served. Good luck on your other case, sir.
Thank you.
Next matter I have.
I wasn't naked. That's what it says here. Okay, now we have a peer in DeSanto, and Bad Lawyer is back. And then we're getting to our main event, Sob City It Part 3. Extreme shrinkage.
Good afternoon, Mr. James. Good afternoon. And, all right, counsel, ask your appearance, please.
Yes, Your Honor. John Roll for P 30758 on behalf of Mr. Davis.
All right, Mr. Davis, your name, please. I mean, I listened to you. See, I was listening to you said Mr. Davis. I said that I thought something's not right.
This is the wrong one, Your Honor.
Okay, Mr. James, your name for the record, please. All right, thank you. Okay, and you're in affirmation with this court, aren't you?
Yes.
What are you affirmation with us for?
Yes, Your Honor.
And so now you're here for disorderly conduct.
Yes, Your Honor.
Okay, as to the arraignment, counsel.
It's been used to charge waive the full reading of those charges and ask that he not guilty of the entry.
Well, waive the full reading and to plead not guilty for purpose of the arraignment. And as for free trial, counsel.
Your Honor. I also spoke with the prosecutor. I also spoke to.
You started to trail off.
I also spoke to the prosecuting attorney as well as with Ms. Shaw. She brought to my attention, which I was aware of because I was involved originally on the previous matter. After discussing all of that, it's my understanding that there is an offer to attempt disorderly conduct. The allegations are such that it needs to be disorderly conduct. There's also a recommendation, which of course is put to this with continued probation with the matter that is now before Ms. Shaw. I've explained everything to Mr. James. He understands that his actions were wrong. He understands that this is something, as he said, I can't be doing stupid things. And it also indicates to me when we first started conversations that he just, he couldn't help himself. I hate to say it that way, Your Honor, but those are the circumstances that we now find at this point in time. He does understand his.
So he thought it was appropriate to go up to a camera?
No, I was, okay. You didn't think anything was appropriate, Your Honor.
I didn't mean for none of that to happen. I didn't know there was cameras around.
Were you on someone? I'm trying to figure out where were you at? Were you on someone's porch?
No, I was walking and stuff, and I drank too much water and stuff. And I was like, dang, I gotta go use the bathroom, and I don't think I would have made it at home and stuff where I was going. So I didn't even remember that.
So he peed. Yeah. I don't know who has it worse, DeSanto or Washington. I love his headphones.
All right.
Yeah, Judge.
Raise your right hand. You solemnly swear or testimony you're about to give in this matter, the truth, the whole truth, and nothing but the truth. Okay.
Oh,
And sir, you heard the speech your attorney indicate on the record, correct?
Yes.
And you have the amended charge of attempt disorderly conduct. How do you plead?
Yes.
It was attempted disorderly conduct, so he didn't quite get disorderly.
And you've gone over your advice and rights with your attorney, correct?
Yes.
I'm sorry?
Yes.
And you understand by entering into a plea to be waiving some of those rights, specifically your trial and appellate rights.
Yes. Yes.
And
Hit that like.
you understand that by entering into a plea as well, you understand the possible penalty as a result of your plea.
Yes.
And the recommendation is for you to continue probation through your other matter, correct?
Yes, ma'am.
And knowing all that, you're still going to continue with your plea.
Yes, sir.
Has there been promised anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And counsel, if you can please respond to your client.
Thank you. Mr. James, back on May 4th of 2023, were you in the city of Wyandotte?
Yes.
And did there come a point in time while you were walking down the street in the city of Wyandotte that you had to urinate?
Yes.
And did you urinate in public, creating a disturb?
Okay. So I went into that as
Thank you. I was going to forget, but
I forgot I had my youngster out.
Okay. So in other words, while you were going into the alley to urinate, you had already unzipped your pants, and so that was exposed. Is that correct?
I'm sorry? What was that? Okay.
Thanks, I've
What about
I tried to fix the sound. It was just not happening today in DeSanto. The recording, guys. We just have to grit through it. It's the courtroom.
Actually, I could report with up to your plea, the amendment charges since the original charges for the plea agreement, and schedule this matter for sentencing.
And then she was freezing. Did you see that?
5/27
She needs an upgrade.
at 10:30 a.m.
Thank you.
Got the docket that day, counsel, and so I said you're on the docket that day.
Oh boy, Mr. Peer. Okay, I'm gonna give you a quick. We're just gonna see her. She showed up in the court. She's talking to her. DeSanto. They didn't have that good of an exchange. I just wanted to show you in all of her Pam Grier glory. She was here, and her client looks good, actually. I hope she does well. I was rooting for her. Wendy got her through it. Wendy Barnwell, for all of her awful representation, has got this woman through it for now. So hats off. We are going to solve City It Part 3. He's in a van down by the river. Let's roll.
I don't have a lot ready, but Mr. Milton is here pro se.
Mr. Milton.
Address that.
That's on it. Is he on Zoom or is he on? Oh, Mr. Milton, there you are. What's happening today? This is on for trial confirmation, Mr. Sharp.
Seems prepared to confirm, Your Honor. One quick note I want to put on the record, though. So Mr. Milton did provide a witness list. The city's also provided one to him. Just wanted to point out that a couple of those witnesses are unknown to the city, and the nature of their testimony has not been provided. Maybe that'll be something to be received before.
The best part is, guys, the judge goes through the names of his witness list. Just wait.
For confirmation, but
I
that
won't
could be an
spoil
issue.
it.
I did request a continuance at pretrial, and it appears I was denied. But
Okay, are you renewing that request now, or do you?
Is that something I'm able to do? Realistically, from what me and Matthew had spoken about, it seems that if I'm unable to articulate,
He calls the prosecutor Matthew. I cannot.
That I knowingly broke the law, and I'm also able to defend myself in trial, then I'm not even able to accept the plea without lying to the courts, which doesn't seem like a smart move to me. So I think doing the trial is probably just the best idea.
I'm not sure I completely understand that.
Sure.
So
what question?
My question to you is, are you this is on for trial confirmation. When both sides, I just heard from the city, look, we're ready to go to trial. And then you either say, yes, I'm ready to go to trial too, let's confirm to trial, and then you mentioned a continuance, and I'm asking, are you asking to move the trial and or continue the trial and I can discuss that with you, or you're ready to go to trial, and the trial is set for, let's see what day we have here.
28th and 29th.
The 28th and 29th. So you'll need to be here in person for that. You understand that?
No, I did not understand that.
Well, you do.
Okay, well, I will not be able to be there in person. I've just relocated north to deal with a warrant that I was told I needed to deal with from my DUI case. So,
so hang on just a minute.
Sure.
So the warrant, it looks like that's out of Skagit County. So are you up in Skagit County? Is that what you're saying to me? Someplace?
Yes, I will be here in probably the coming week. I've got a gas tank that's full right now. I'm working my way to handling it before my DUI hearing, I believe it was on the 26th. Now it's on the 7th of July.
The DUI case here in Thurston County.
As a matter of fact, I am. Yes, it is. Thank you so much. Thank you. Yeah, so the judge told me that I would look a lot better if I went and handled this before I had my hearing. So I told him that I would, and that's what I'm doing.
Okay, so hang on just a second. Again, my computer's slow here. Yep. So do you have a court date set on that? How do you intend on taking care of that warrant out of Skagit County?
It appears to be a book and release they refuse to transport me for, so I have to drive up there myself and go and turn myself in and then get released, and then they'll set a court date for me.
Okay. And when do you plan to do that?
I'm working my way up there as of just a few days ago. The 15th, okay. I made it just past Seattle.
Okay. So you're north of Seattle now?
Correct.
When do you intend to be back here in Thurston County? Did he?
That's a great question.
Thank you.
Yeah, sure. I guess I wasn't intending that I would have to.
Well, your court date in this DUI is, you're correct. That's July 7th. You can Zoom on that. But for jury trials, we don't do Zoom on jury trials. You actually need to be here in court for a jury trial.
Interesting. Okay. Okay. All right.
So you can be out of town and make your July 7th court date. That's not a problem.
Yeah.
But I don't want to confirm for trial if that trial is not going to happen because you can't be here. So that's why I'm asking these questions.
I appreciate that. Yeah. Thank you very much for helping me decide that's absolutely not optimal then. Yes, I would absolutely like to request for a continuance in that case.
Do you have a mailing address?
Yes. Yes, I do. I have 2 of them.
I want the most reliable one.
Okay. So the one in Anacortes that I will apparently be leaving behind to go back to deal with Thurston County would be 5207, but that seems irrelevant if I'm going back there, which it'll remain the 5213.
Okay, thank you.
Yep.
Did you get a text reminder of this court date?
I did not.
You have a cell phone where we could send you a text reminder of court dates.
I do. I've just gotten a new phone given to me by someone. And I don't know my phone number quite yet. Unfortunately, that makes me seem very less diligent than I'd like to appear.
Okay, can you provide that court date or that telephone to the court when you learn it?
Yes, absolutely.
We have a text number for you. It looks like the last 4 digits are 9283. Is that right? Is that an old number that's no longer good?
It was stolen from me.
Okay. So I don't know if you've had conversations with any judges about what going to trial is like. Have you done any of that?
I've done a bit of research, but
no, I mean conversations with a judge in court here.
That would be a negative.
Okay. Have you ever conducted a trial before? Either any sort of trial, either jury or bench trial?
Negative.
Have you ever been present when a jury's selected for a jury trial? You'll have the opportunity to question them. And then at the conclusion of that question answer period, you can exercise certain challenges for jurors in certain circumstances or excuse them for no reason, which they call a peremptory challenge. You ever seen that process before?
I have not.
Do you go to law school? I'm assuming you're not a lawyer or didn't go to law school. Is that true?
You think?
I have not passed my bar exam, but I'm not aware that I'm required to do so.
Oh,
you're not, but I'm required to put all this on the record. So when you go to trial representing yourself, so then you don't come back later and say, well, I didn't get effective representation, which you're entitled to. And so then I want to put, basically, you want to eliminate this as an issue on appeal. You see what I mean? So no, you're not required to, but I do want to get this on the record. So, you're going into this process with open eyes.
I appreciate that. Thank you.
You ever had training in the rules of evidence or rules of criminal procedure?
Yeah, okay.
Not that I'm aware of.
And then you understand the attorney, Mr. Sharp, who represents the city of Lacey, is an attorney, does have training in the rules of evidence, is aware of the rules of criminal procedure, and been through more than a few trials. And so he would have a significant advantage over you if this case were to proceed to jury trial. Do you understand that?
If I was guilty, I would say yes, but I'm going to have to say I understand that he's more credentialed than me, but I don't understand the advantage.
Well, running a trial, I'll try and do my best to explain the advantage. And that is, running a trial is not a simple thing. It's kind of a complicated thing. And people who do it for the first time, it's a pretty steep learning curve there. When you walk into something you've never done before and have no clue about how the courtroom works or rules of evidence and criminal procedure, and you're going up against someone who has a very sophisticated knowledge of those things, That's going to be a pretty big advantage for the guy who's got that knowledge. Do you understand that?
Sure. I can get behind understanding that.
And you understand that you have the right to an attorney. I can appoint an attorney to represent you, who would be on a much more even playing field with Mr. Sharp.
You know, I've been made aware that the public defense owns a YouTube channel, and I've witnessed that that particular person who was set to appoint me once upon a time benefits greatly from misrepresenting her clients, and I would rather not be misrepresented intentionally. But thanks.
What a dick! Wait, the Thurston Public Defender's Office has a YouTube channel? Does anyone follow that? Oh God, I can't. I love it. He's so bad.
You're wrong about
He's so bad that it's fantastic. It's just one of those. It's so bad that it's wonderful.
a few things.
That's all right.
First, she doesn't have a YouTube channel. We stream all these cases are streamed over YouTube through the court, not through her or anyone else. And I'm not even exactly sure who you're talking about. And so, but if that's a long way or your way of saying you're aware you have the right to be represented by an attorney and choosing not to take advantage of it, then we can go forward. Is that what you're telling me?
Yes, that is absolutely correct. It would not be in my best interest from my understanding. Thank you.
Okay. And that might be another point where we might agree to disagree on. I think it would be to your advantage to take advantage of an attorney who frequently appears here and, again, has the same level of knowledge of the rules of evidence and criminal procedure, but you have the right to represent yourself. You do that. I just want to make sure you're doing that with open eyes. Do you understand that?
I appreciate you, Your Honor. Yes, I do understand.
So let's talk about a trial date then. So if you're not going to make I'm not going to confirm for trial if you're not going to be here at your request. And so this time will be excluded from speedy trial calculation. I'm going to work on a date that makes, that works for everybody when you can be here. So when do you think, again, I want an accurate date of when you're going to be back here, and we'll reset these dates right now.
Right. Let's schedule for perhaps late July if possible.
All right. And so we will do that. The clerk's going to find some dates here in just a minute. We're going to set, this is what's known as a confirmation date. We'll set a confirmation date. We'll also set jury trial dates. And now I want to talk to you a little bit about discovery and or witness lists. Okay. So one of the things about the rules of criminal procedure is that you have the right to call witnesses, whoever witnesses you wish to call, but you have some obligations too. You have to let the city know who they are and how to get a hold of them so they can interview these witnesses, just the same as the city has the obligation to tell you who your the witnesses are going to be and how you can get a hold of them. Do you understand that?
Do you recall me providing you that list?
I'm not the prosecutor, so you didn't provide me to anything.
Oh, I handed it to you to hand off, and I handed it to Matthew Sharp as well.
Okay, so I can ask Mr. Sharp, and he wants to say something. I'll hear from him, Mr. Sharp.
Sure, I just thought it'd be helpful. I think the court does have a copy. I believe Mr. Miller brought 3 copies.
Okay, we might, but I don't. It's not the obligation to get it to me. It's the obligation to get it to you.
And we got it, and I'm looking at it right now, and he certainly lists several people that could be witnesses. Again, the city is not aware of what they would testify to, and as the court points out, there's not contact information for the city to conduct interviews ourselves.
So can you get that contact information, how to get a hold of these people you wish to call as witnesses?
And I can share, Officer Beavers is listed.
Wait a minute, Mr. Sharp. Okay, go ahead, Mr. Milton.
That is why I requested the pretrial continuance, and I rushed around to get the information. I know how to get a hold of them, but I don't have their private information. I only know how to get in touch with them, to tell them to appear and help me not get put in jail. So
I don't know that, given your record, Mr. Milton, I tend to doubt that this is something, given the nature of the charge combined with your record.
My record? Oh, I didn't have one
Yeah.
before I defended a
Right,
senior.
that's my point. You don't have one. So I don't think you really need to spend a lot of time worrying about jail on a charge like this. That's my point. You don't have a record. You're right.
Sweet. Sweet. That's awesome.
But you never know.
Right. Yeah. I won't pretend to know.
Okay,
until
so hang on just a minute. We're going to give you some, we're going to get some court dates for you.
Appreciate it.
And I want you to write these down because they'll get sent to you at the address.
Okay.
By the way, you're not driving now, are you?
Correct. I am not. I'm waiting
Great.
outside of the Planet Fitness to work out.
Ooh,
I just want to make sure you're not driving.
The gun
Believe it
show.
or not, sometimes people call in when they're driving, and I always try. I make them stop.
Look at him.
I believe you.
Okay. Do you have something you can write down court dates with?
I am looking around for a pen right now, and normally I am not without one, but it appears now is a rare situation where I am. Ah, here we are.
Confirmation date.
Confirmation is 7:25.
Confirmation is July 25th at 10 a.m.
Okay.
And that for that hearing you can zoom into, but the jury trial is going to be July 31st and
Okay.
April 1st or August 1st. April, where'd that come from? August 1st.
July
So the 31st and August 1st.
All right. And are those both at 10 a.m. as well?
No, those will be at 9, and those you'll need to be in person for.
Okay.
And then I'm going to rely on you to get that information to Mr. Sharp. You can get it to the court too, but it's more important that it gets to him. Any means that he can contact the witnesses that you intend to call.
Awesome.
Yeah, before we wrap up briefly, I guess, Mr. Milton, I trust you, you know how to get a hold of my office with that information. And please reach out if there's anything else to discuss with the case. But I wanted to bring up and ask the court about the possibility of if Mr. Milton would be interested in standby counsel. And I bring this up because at the beginning he had explained that there had been some negotiations and that the way he described the conversation, it sounds as though maybe he could benefit from having somebody he could ask some questions. For example, he's not apparently aware of the Alford plea process. That may be applicable and it may be something he would be interested in. I am not in a position ethically to explain that to him. And I just want to make sure that he has the chance to ask for counsel, to have somebody on standby to ask questions of.
Mr. Milton, what's your response to all of that? Standby counsel is someone who doesn't represent you, but that just is someone you can, again, speak to, again, about the things that I spoke about: criminal procedure, rules of evidence, perhaps trial strategy, kind of a speaking library, if you will. Is that something you're interested in or no?
I will pass on it this time and enjoy the ride. Thank you.
Enjoy the ride. And
Okay, hang on just a minute.
Biggest douche ever. He's gonna enjoy the ride.
Okay,
Look at
and
him,
so, and again, I'm just looking at your witness list here, Mr. Milton. Witness number 5 is this handwritten, someone named Repa, R-E-P-A. Witness number 6 is just Shaggy.
Repa and Shaggy. I can't. Oh my God. That's it. He's in the mystery machine. That's where he is. And Scooby's, he's defense attorney.
And so you're going to need to be a little bit more specific than that. You know, provide named Repa, R-E-P-A. Witness number 6 is just Shaggy. And so you're going to need to be a little bit more specific than that, provide, actual names and contact information. Do you understand this?
Sure. As soon as I go and get all of this information that I would never ask for somebody from a personal level, then I will be sure to inform the courts of the detailed information.
Okay, hang on just a minute.
And obviously, Officer Evers is listed there, Your Honor, but the city knows how to contact her, so we're not worried about that.
And you're going to be responsible for making sure these folks show up too.
Okay.
All right. That's it for today. Notice of your next court date will get sent to you at the Boulevard Extension Road. When you get a phone number or you remember your phone number or figure it out, then let the court know what that is. We'll also send you text reminders.
Okay.
But again, I'm going to repeat these just so you know, on the 25th at 10 a.m. and then on the of July, and then the 31st of July and the 1st of August at 9 a.m. And the 31st and the 1st, you'll need to be here in person.
Okay. In person. Thank you, Your Honor.
You're welcome.
Have a
That's
nice
it for
one,
today.
guys.
I'm sorry?
Oh, have a nice one.
Thank you. You too.
Heck yeah.
Heck yeah. Heck yeah. There it is. Solve Sit Part 3. Remember, first time you saw this moron was on my channel. And then Team Skeptic picked it up and it went crazy. But I am, after his trial, I really think, I pray they televise that, put that on Zoom. Because I have all of his appearances and I'm going to make a big, just master copy of all of his appearances on one video. Because Mr. Milton is a classic in LawTube. So, guys, I hope you enjoyed the midday live. I'm going to be doing this a lot more. I am taking the night off. I'll see you guys later. Enjoy the rest of your night. I am Phil. This was Time a Serve. See you later.